here with part 112 of the My Docket series and child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my access parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. So we go into my motion for order to show cause, which is basically trying to hold my ex in contempt of court for non-compliance with, if I remember correctly, the homework packet exchange provision. And going into my mindset, I can remember a couple of things from this point in time. Number one, I was frustrated because we just got out of court, and here we are going right back in. And some people, including my ex, would say, well, Alex, you're in control of that. Just don't file anything. Just let her not do the stuff she's supposed to do. And I guess to some extent, people will think, yeah, the child will suffer, but it's not your fault. And I guess the way I saw it was, well, it is my fault if I can do something about it. And I did go ahead and do something about it. I filed this motion, and she was held in contempt of court. It worked. And she stopped doing that. There are other things that she would continue to do, which would, cause her to lose all of her other parental privileges. But at least she stopped not exchanging the homework packet. One other dynamic to this is the fear. I didn't want to file something because I remembered what happened last time. The court didn't really care that I was trying to help help my son out, help the situation out. By situation, what I mean, the teachers, the school, because I didn't want them involved in our conflict. So it's not that I just helped her son out, but I was able to remove the teacher from the equation so she didn't have to create an extra packet. All that stuff I was trying to do didn't matter. They still wanted to impose sanctions. I was able to bargain it down to $500 some, but I still came to the conclusion that the court isn't really interested in the fact that you're trying to help your kids or not. The court is interested in the fact that you're filing papers without an attorney. I say that specifically because people with attorneys who file papers all the time, it's not the same thing. The court looks at the lawyer and goes, well, that's your job, you're making money. The court looks at the non-lawyer and goes, why are you annoying everyone? And that's what leads to all of the problems connected to the video defend against attorney fees, and also connected to the video end of filings is not end of abuse. Take a look at those two videos, and that kind of mixes in with the whole fact as to why are lawyers doing this when it's not good, it hurts families, and the answer to that question is the video, win at all costs. So we are going to go ahead at this point. Oh, I should explain why I still filed it. I still filed it because after I filed the motion for reconsideration, I realized that there were other laws in place to protect me. And so I kind of built my confidence up a little bit, and I thought to myself, if she does try and get attorney fees again, I've done all this extra research, and I found out a few more ways I can get out of this so that I can defend against attorney fees even if I lose the emotion. And it was a very real possibility to me, because now my perspective isn't so much what it was back then. I do remember back then I had this idea that the judge just hated me and wanted to find reasons to sanction me and deny my requests. So anyway, I think at this point in time we can go ahead and take a look at what I have filed. Here we have my motion for order to show cause. Standard introductory paragraph indicates that I am the petitioner filing this without an attorney. That's what I mean by appearing in proper person. I am indicating to the court that I'm filing a motion to have my ex ordered to show cause why she should not be held in contempt. Okay, summary of motion. I'm seeking an order of contempt against my ex for violating an order to disclose. Okay, so this is for the medical, dental, vision, and insurance cards. And okay, so yeah. Here we go, the separate order requiring her to exchange homework. Factual background. Okay, okay, it's just a standard summary factual background for the first paragraph. I am indicating to the court that I'm the natural father. I have sued my ex-natural mother, and that the court gave us both physical and legal custody jointly, and that I filed a motion to have my ex ordered to reveal her medical, dental, personal health insurance information, including the benefits cards, I would assume. On August 14th, she filed the opposition. She basically didn't want to do that. On August 26th, the court discussed in its order and mentioned, okay, so this is the court stating what I call generic legal custody principles. This is not really considered an order that you can use to hold someone in contempt of court, and I made this mistake filing this motion, at least for that part. The homework packet's still lumped into this, and that's going to still go somewhere. But this portion here isn't going to work. When courts state generic statements like this, they're unenforceable. You can use those statements later on to modify legal or physical custody, but you can't hold somebody in contempt. Because this doesn't give my ex something very specific that she needs to do. This just gives her a sort of overarching big picture view as to what joint legal custody entails. So yes, she's violating joint legal custody principles, but she's not violating a court order, at least not on this point. Court continues this discussion. I'm not going to go over this again. We already went over this court order in this My Docket series. On November 30th, I filed a motion to set a procedure for these appointments. On December 14th, my ex filed opposition, and on January 12th, the court determined that the case was ripe for review. We went to court on May 10th. The court entered an order after ordering my ex to schedule appointments and give me notice. I sent my ex an email concerning my son's lower molars. My ex filed an ex parte motion for, no, I filed an ex parte motion for temporary restraining order on April 27th regarding the tonsillectomy, I guess. On March 27th, the serious concerns about the size and color of our son's cavities were brought to the dentist's attention. That's correct. On March 28th, I collected my son from daycare. Our son was distraught, in pain, and crying. On March 29th, I responded to my ex's email that her evasive answers were not acceptable. So basically, I hope, okay, it looks like these are included in this motion. So I'm going to take a look at these email exchanges when we get down there. For now, what I'm going to say is my ex was responding to emails in a way that she thought would strategically keep her out of trouble with the court while simultaneously not taking care of our son's needs. And we'll look at the details when we get to those emails. April 1st, I filed the affidavit of the daycare owner. We already went over that last video. April 27th, my ex failed to provide our son's homework packet for the 4th time since the court's order. Going into the next provision here, my ex did not schedule our son for a dental appointment, nor did she disclose his dental and vision insurance information. Legal analysis pursuant to the law, and this is the definition here of contempt. We've already talked about this before in 2 of my previous contempt motions, but basically, to constitute a basis for judgment of contempt, the order that is, being sought to be enforced has to be clear and unambiguous. That's the part here that gets a lot of people, because they try and just get their ex on, principles of morality and fairness and, logic, but contempt doesn't work that way. It's, you were commanded to do this specific thing and you didn't do it. Next, we have that I have attached the NRS 22.030 affidavit in support. This is called the Awad v. Wright affidavit, guys. I talk about this in my video, Contempt of Court. If you don't take a look at that video, you won't know about this affidavit. And if you don't know about this affidavit, you may not be able to get anywhere with a motion for order to show cause, because this is the affidavit that gives the court jurisdiction over that particular issue. On May 26th, the court entered an order after hearing requiring us to use in-network coverage providers and indicating that a failure to do so would violate the parent, or would make the parent 100% responsible for the bill. My ex is claiming that insurance cards don't exist and refusing to disclose in-network dental providers. She's trying to basically cause this to occur. She's trying to get it to the point where I accidentally use an out-of-network provider so she can try and force me to pay the entire cost. That's what she's doing. By the way, guys, if judges don't think people do this, they need to be fired and removed from the bench. They do this. I don't understand why some judges don't think this is possible. If you order that an out-of-network use is going to cost the parent 100%, and that other parent has the ability to not tell you who the in-network providers are, will some parents do that on purpose just to make you accidentally use an out-of-network provider? The answer is yes. Some parents will do that. There are judges who don't think that this is a possibility. Do whatever you can to fire them, take them off the bench, because they don't know what they're talking about. This is exactly the type of mindset that antisocial people have. They're not constructive people that are looking to take care of their kids. What they're doing is trying to exploit weaknesses in any kind of system that they can find to take advantage of them. They're manipulators and exploiters. They're not facilitators. They're not cooperators. They don't want to sort of work together to solve problems. They want to find weaknesses and cracks and exploit them for their own personal gain. This is stuff that's, I don't even know why I have to mention this in the video, but having talked to enough of my viewers, it's clear to me that some judges that are on the bench in family courts have this bizarre notion that every parent who comes before them loves and cares about their kids. No, not all of them. I will say most of them, yes, but there are the rare few that don't. And they are just using their kids to get whatever it is that they want. And this is one of the, like, these are the tactics that frustrated my judge, because it was like he just couldn't get his head around the fact that a mother would do weird things like this, like take all this effort, do all this plotting and scheming. And it's like, come on. This is why the case went on for 8 years, because he wouldn't open up his mind to that possibility and pay attention to the evidence and the facts. Anyway, that's my tangent, and I'm going to go ahead and move on. It's just really frustrating for me, because when I describe these things and I just kind of look over them and I'm like, yeah, right, some judges don't think that this is possible. They think I'm saying that the sky is purple or something. Okay, I have considered a number of possible solutions to our son's suffering before filing this motion. And then I go through all the things that I've done to try and avoid having to go to court on this issue. And one of the reasons I do this is because it works really well. I haven't, succeeded yet, but it works really well when you show the court that you're trying to hold your ex in contempt, not to punish them or as a weapon, but that you're doing it as a last resort because everything else that you've already done didn't work. It's like, there's a difference between contempt being your first resort, which is covered in the video Gotcha Litigation, and contempt being your absolute last possible resort. Next assertion is that in the instant case, it's become a never-ending conflict. It's come to the point where my ex's stubbornness and refusal to cooperate has evolved into a full-blown defiance of the court's authority. And this is true. And it is our son who suffers most from this. For the several reasons stated above, my ex should be imprisoned under the law for a total of 4 days. So I'm asking for a 4-day sentence in jail. Then I go into the hearing, and this hearing here, okay, so in order for imprisonment shouldn't issue summarily, my ex has to have, yeah, this is required by law. The court can't summarily order her imprisoned. The court has to set a hearing, and she has to be forced to appear at that hearing to explain why she shouldn't be held in contempt of court. There are a lot of things that a judge can do without a hearing. This is one of them that he can't do. Mediation is futile. So now I'm starting to actually use this paragraph. You're going to see this pretty much every time in the future. Like from this point on, I'm going to brief the court over and over again and tell the court, please don't send us to mediation. It's a waste of our time and money. It doesn't go anywhere. And I have explanations and citations to law as to why mediation is not appropriate in this case. I'm requesting clarification on the costs of emergency room visits. And I guess this has to do with the dispute between my ex and I. She doesn't want to pay the cost for our son's emergency room visit on the grounds that she didn't approve of him going to that particular hospital. Conclusion: if a parent can do what he or she wants regardless of a court's orders, the purpose of our society's civil procedure is defeated. And that's true. Why go to court if somebody can just ignore it? And that's one of the things that judges seem to not understand. Like, sometimes they'll do this, but there are other judges who are like, well, I don't want to do that. That's mean. Okay, well, we basically went to court for the past 3 years for nothing then, because all of the judgments that you entered, you can just ignore them. So this is one of the principles here behind contempt of court, is there has to be a reason as to why we're even going to court in the first place. You have to bind people to these orders, because if you don't, then the whole process is just a farce. And here we have the prayer for relief, which is that my ex be ordered to show cause where she should not be held in contempt of court, and that upon her contempt for failure to disclose the insurance benefits card, she should be imprisoned for 4 days, and that on the failure to exchange homework, she should be imprisoned for 1 day. Next, here we have my declaration, which is indicating that I've read my motion. Okay, so this is what's verifying that this particular document is sworn under penalty of perjury. As to the facts specifically, I'm basically swearing under oath that the facts alleged here are true. Here we have my Rule 5 certificate of service indicating that I personally served this document to my ex's attorney at our law office. And here we have the motion opposition notice, which for a contempt of court does not result in the paying of the $25 filing fee. List of exhibits. We have a bunch of emails, 1, 2, 3, 4 emails, medical center report, the affidavit in support. The only 2 things that I will skip, actually, there's only one thing I'm going to skip over, and that's Exhibit 7, because I've already gone over this document a number of times in the series anyway, but I'll go through all the other exhibits because they're new. Exhibit 1. Okay, so what we got here? My ex is saying that the eye doctor hasn't changed. After the old dentist passed away, she hasn't found a good one. She's been calling around for the last few weeks, and she thinks she found 2 options. She'll let me know. Healthcare went up, so she's trying to raise child support again, which she can't do. Same exact thing that the court told her she couldn't do, she's trying to do again. I don't understand this. Anyway, she just doesn't listen. She tries to just change the child support when she feels like it, because I call this the feeling of specialness. She doesn't think the rules apply to her. She thinks that she's a special person who can just invent her own rules, and that everyone else has to follow the law, or everyone else has to follow the law and the rules of the court, but she can just she's special, so she can just tell me how it's going to work going forward, and basically what she's trying to do is tell the lawyer and the judge how it's going to work. But anyway, I'm going to go ahead and continue on now. She's trying to say that she doesn't have a dentist right now because the last dentist passed away, and basically our son has no dentist. And I'm saying here that I'm still waiting on the eye doctor's information, and I'm concerned with the 2 molars. That's why I mentioned here they're in bad shape. We need to get them in for dental work. Exhibit 2. Okay, so my ex says it's on a Monday. They don't have a for sure time. Okay, checking in at 5:30. She says she'll be there for 46 hours. What is this? This might be the tonsillectomy. So, what is this about here? Okay, so I'm telling her that I need to know as soon as possible, and that I don't want to tell my boss at the last minute that I have to vanish suddenly for a tonsillectomy. And this is actually one of her tactics, and this is what comes up in court. She does it on purpose. Once they find out what it is that's going to frustrate you, they deliberately do it. Exhibit 3. Okay, Exhibit 3 is the okay, so this is just that our son needed emergency care for the pain in his mouth, and we've got the dental care and stuff here listed. It's just bills and details as to what's wrong with him and stuff like that. And then the dentist is identifying the lower right tooth contains a large cavity. Same thing, just an extension of the suffering of our child. Exhibit 4. Okay, so you haven't shown. So she's saying that I haven't shown her any bills, which isn't true. She has been shown bills. Something about not showing up for the surgery. love how she puts right here in the parentheses, because I don't care. Basically, she told me the surgery at the last minute on purpose, and I couldn't get out of work. Lovely. And that, of course, means that I don't care. So she's saying here that she's provided all the names of her insurance without providing the names of her insurance. This is what I meant by evasive responses. I'm trying to get her to give me the names of the insurance providers, and she's telling me that she has provided all the names of the insurance providers. A normal parent would just provide them again. But what she's trying to do is insinuate that she's told me at a prior date. And look, she's not even providing citations as to when she told me. So there's no date, there's no time. Unless she's trying to use, I guess you could say, it's not even legalese. It's sort of a contortionist view of her perspective as to having complied with the law. So she might be saying, without saying, that she complied with the previous court's order to tell me what those names were. And since she's complied with that order, she doesn't have to tell me anything more, even though the names have changed now. But she doesn't give you any of these details. This is actually one of the ways in which they use language as a weapon. Actually, please, if you guys can get a chance, watch Sam Backman's video on language as a weapon, because he describes how they communicate to people in a different way. Whereas we, ordinary, normal people, try to use communication to sort of foster a relationship, to coordinate, to communicate, to clarify, to solve problems. They don't use communications that way. They use communications to sort of fend off, to delay, to obfuscate, to confuse, to distract. It's mainly like, they see it as like a strategy or like a game that they're playing with, and they do this with everyone, really. Anyway, same thing that she's doing here is she's telling me, she's dodging my questions by telling me that she has provided me an answer without giving me the names of any of these things so that I don't know. It's on purpose. This is not an accident that she's doing. And then she's going into a lot of the declaratory statements that she makes, like, don't email again, it's common sense, blah, blah, blah. This is just an opportunity to, what I call snipe and microaggression. Here we have, so she's telling me don't email again, so I'm saying the only thing I can do is file a motion to have you held in contempt. And I want you guys to see this, like this attitude. Don't email me again, it's common sense, you don't care about our son, don't email again. And then my response, okay, I'm not going to email you, motion for order to show cause. And then the judge's response, cuffer. So they can have this attitude of invincibility, like they're in control and like they know what's going on and that you're annoying them, and then 2 months later they're in handcuffs crying. Literally, she was crying. So it's like, don't be deterred, guys. Watch my video, How Abusers Win. A lot of what they try and use against you is psychological warfare, and they try and psych you out, and then when you actually get to the battlefield, which is the courtroom, all of a sudden they're just totally flattened. And I don't even know if she was really surprised. I think she was surprised that it litigated all the way to a hearing. I think she had sort of this idea that she was screwed when she went to court. I don't think she thought that I would actually do it. Anyway, guys, we're going to see that hearing when we actually get to it in the My Docket series. We can talk about it at that point. So here I am saying I'm going to file motions because that's the only thing I can do. And then she's talking about how we're supposed to pay up front, so I have to show up and pay my half. By the way, guys, she didn't even pay her half. So I show up and I pay my half. This is what I love about this conflict. So she tells me, I'm not going to do this, I'm not going to do this, I'm not going to do this. And then at the end of the road, when I finally have her cornered, she says, okay, well, they want us to pay up front. So if you show up and pay your half, then it'll get done. So then I go there and I pay my half, and she doesn't pay her half. And then, in fact, she reneges. A few weeks later, she says, never mind, I don't agree with this, and I don't think he needs the surgery. It's like, hold on a second, you told me if I paid my half, you know, this was going to happen. So I go over there and I pay thousands of dollars, and then you say, never mind, I'm not going to do it, and I'm the one that apparently doesn't care about our child. So this goes all the way to the modification hearing, and the judge is livid, because the judge is like, not only did you try and do everything in your power to stop him from getting treatment, but you even like, you even lied about saying you were going to pay for half of it. So it's just she sets herself for this monumental and catastrophic defeat without even realizing that she's doing it. And I really do think that most of the game for her was not in the courtroom from the beginning. I hear a lot of people tell me their ex is a master manipulator, they're conniving, they're a great liar. But I feel like, in my experience, as I look over these cases, and including my own case, it looks to me like they really don't angle themselves for a win in the courtroom. It's like they angle themselves to try and get you to just give up. Their whole entire approach is an outside of the courtroom approach. That's my perspective with a lot of these abusers. They're not even playing in the courtroom in the first place. So if you could just get them in there, which is very difficult in some of these judicial districts. I mean, I heard of one of my supporters saying he didn't get a hearing until a year and a half. But once he got the hearing, he won. And then there was the guy from Viewers Victory #1, same thing. He waited like 8 or 9 months. It felt like he wasn't going to get anywhere. Then he gets a hearing and he wins. It's like they know this. They know that the weakness is the system itself, and so they try to play the game outside of the system. Next we have info on what dentists are covered. Her dental insurance is fine. I don't need to get dental insurance on top of her insurance. And then here is me saying, hey, did you get an email from the dentist on an appointment for our son? Exhibit 5, me telling my ex, hey, I didn't get the homework packet again. Not sure what's going on. Exhibit 6, okay, this is the affidavit in support of contempt that I talked about. Guys, this affidavit should mirror the motion. I don't think it's going to contain anything different in it. So for that reason, I'm going to go ahead and skip over it. As with all my previous videos, if you look down in the description below, you will see some links. You can click on the links. You can download the document for yourself. You can take a look. If you see anything that you want to talk about, post it down in the comments below. I'll talk about it. But as far as I know, the affidavit in support of contempt is, for the most part, something that mirrors the motion for contempt. It's going to contain all the same facts asserted. And it's just swearing under oath separately in a separate document that everything sworn and alleged is not only true and correct, but constitutes contempt of court. Exhibit 7, which is this police report that I've already gone over in the My Docket series. Same thing as before. It'll be down in the description below. Just click on the link if you want to read it again. We've already gone over this document. It's nothing new. Here we go, Exhibit 8. So this is me just proving that I paid. So I paid for that ER visit. That's what I'm stating. Next document, we have the affidavit of my wife, Brittany Ames. As with my previous review of affidavits, the first 4 statements are typically, in this case it's just the first 3 statements, so I'll go over numbers 4 and 5. The first 3 statements are the same. I put them in pretty much every affidavit. Number 4 says that on the 17th of April, she witnessed me and my ex exchange our son, and my ex did not provide the homework packet, and that her relationship to me does not affect her truthfulness, and that she is willing to appear should the court deem it necessary. And what she means by that is to appear and testify. And here we have the Rule 5 certificate of service indicating to her attorney that, indicating to the court that I served this document to my ex's attorney personally at her law office. Notice a change of address. I'm just indicating to the court that I have changed my address. I'm indicating the same thing to my ex's attorney, as you can see by the certificate of Rule 5 service. Guys, this document is very important. Please watch my video, notice of change of address. Do not take it lightly. Notice of resolution of pending proceeding. I've covered this in a couple of videos in the My Docket series, and I'm just telling the court that the decision from the Supreme Court of Nevada, Falcone versus Secretary of State, has been published, and that the issue before the Supreme Court is now resolved. This issue will impact this custody case going forward. I'm going to be talking a lot about this decision from the Supreme Court in the next video. That is the video where we will go over the publication, and I'm excited to pick it apart with you guys and explain to you how the Supreme Court ruled, why they agreed with me that I was right, that there were problems with the confidential address program, and why they gave me the gateway that I needed to pass through to get this issue in front of the court and resolved. Without this decision from Justice Cherry of the Supreme Court, I would not have been able to force my family judge to finally address the lies and deceits in my ex's initial restraining order. And it's going to be a little bit anticlimactic, guys, when I eventually do get in front of my judge. You will get a hearing video. It does happen. But what happens is my ex doesn't show up. So she knows she lied. She didn't show up and defend herself, and I ended up winning that because she didn't have a leg to stand on. So you're going to get to see all of that as we get to it, but at the very least, we're going to get to see that first domino that gets tipped over, the one that creates the chain reaction that leads all the way to my ex's termination of her parental rights in 2016. Anyway, guys, I'm going to go ahead and continue on. And we have here the Rule 5 Certificate of Service, indicating that I served this document to my ex's attorney. Going into the aftermath, I filed 1, 2, looks like 3, all 4 of those documents, but they were all 4 free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have had to review these 4 filings. I think the affidavit of my wife, she would have probably spent about 5 minutes on. That document was very, very short, but at the same time, it would have been something that was relevant to any kind of upcoming litigation. The notice of change of address we have, she does have to read that and put it into her system. She has to update. It's at least 5 minutes of attention that attorney needs to definitely pay. She can't send stuff to my old address, or it's going to completely frustrate any kind of litigation efforts with me. So I don't want to downplay that specific document for review and work. The notice of resolution, I don't think she's going to care about. She's going to know it's resolved on her own when she gets served from the Supreme Court and all that. So I'm going to put 0 time on that. So we've got 10 minutes so far. The motion for order to show cause, there were a lot of emails attached to it. And, you know, still, review is different from having to write. So I do think that this document, 20 minutes is warranted for review of that motion, of those emails, of the affidavit that was attached to the motion. I don't think it's going to take a lot of time for that attorney until she files her opposition. I think that's where we're going to get more of those attorney fees at. So I think 20 minutes is reasonable on that motion for order to show cause, and that's going to be a total of 30 minutes at the rate of $250 an hour. That comes to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.